Evening, everyone. How's everybody doing today? Welcome to the Windy City Block by Block Real Estate Show. I'm Dawn Haley. I am your host, and I'm always so grateful to come before you and talk about real estate things and whatever I can do to share any information with you that in hopes of helping you out. But I'm excited today, as I told you, and if some of you caught my commercial. I'm excited because I got my daughter slash attorney, Miss Lisa Glenn from the law office of Lisa Glenn, and she's gonna be on today to talk about a variety of topics. Hey, Lisa, how you doing?
How how's it going? I apologize if you hear a child crying in the background. Um,
That's all
it's
right
kind of
because
her dinner time, so
yeah,
we
that's
do
all
it
right. Hey,
together.
we're living in a world where everything happens at home. So if we hear Miss Haley say a few words, that's okay. But how you doing?
Doing well, and yourself?
I'm doing well. Thank you for asking. And thank you again for coming back on the show to talk about your area expertise. Oftentimes, I usually spend this time to talk about, some things and what's going on in the legal realm of just what you do. I mean, I'm gonna break it down to some topics, but is there anything that got you kind of like, I can't believe that happened.
Well, I mean, with COVID going on right now, there's an uptick in probate cases. I have a number of new cases of people who passed away from COVID, which is very sad.
Yeah,
And I also think with COVID is bringing on a level of stress to family members for people who have both passed and those who have disabilities, because I've had also a lot of family fighting these
yeah,
last, I'd say, 6 months. I've never had this many cases where I've had siblings who just did not get along, um, and are fighting over the smallest things. And I really do think it has a lot to do with what's going on
yeah,
in the
and
world.
right, and a lot of people are struggling trying to find ways to survive financially, and sometimes death can bring out the worst in people. You think that
Yes, it brings out the worst normally, and now it's times 10.
yeah, yeah, yeah. I can, of course, we can't share confidential information, but I've had my deals where I can even share that someone was in a situation where they threatened me, and so yeah, and even now I can imagine. Hopefully, you haven't had any
Oh,
threats.
no one's been upset with me. Well, actually, no, I did have one client. Yeah, she was upset with me, but there was a misunderstanding of what she thought I was going to do,
Yeah,
and she was very upset that I wasn't doing what she thought I was going to do, even though I
yeah,
explained at least 5 times what
yeah.
it was I was capable of helping her out with. So she cursed me out a little bit, but other than that, none of the clients have been upset with me. They've just been upset with each other.
Right. And and the thing that because that I see that and then I'm going to ask you these questions and you let me know if it's true. Um People typically don't know about probate until someone passes away. And that's not the right time to know about probate, correct?
Oh, it's always better to know. It's better to be prepared. I'll just say that. And unfortunately, I've actually had a very recent situation where you also want to make sure your attorney knows what they're doing too, because sometimes people think that they are prepared, and it turns out what their attorney had them do was nothing. helped in no way, shape, or form to making sure that their loved ones' assets were protected after death. So
Yeah, yeah.
you also got to research your attorneys if you are
Yeah.
trying to prepare ahead of time.
And and that goes and of course, if I don't put a bad light on any profession, but you want to make sure when you're selecting professionals, that's their area of expertise. You don't want to, deal with an attorney who's pretty much their area of expertise is criminal law or, their focus. And then
Mhm.
they tiptoe in other things so that they can at least make a, add some income into their coffer. So, you always want to, as you said, that was an excellent point, Lisa. You really want to make sure that you're, whoever you choose to do business with, that's what their focus of law is. So that's a good
Mhm.
point. Now, the second thought is it says nearly half of America, and even less than half, have some sort of estate plan. So is that true?
Less than half? Oh yeah. Um, and it's interesting because I feel like the people who need it the most are the ones that don't have anything set up. It's usually those who don't have a lot going on. They'll do like a quick will or a quick POA, but it's those that actually have things worth protecting
Mm-hmm.
that don't have anything in order. And
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 what?
and and like you were saying before, it's just so many people don't understand. They don't understand that each state has their own laws. So, there's some people who think if they just write something out and sign it, that's all that's needed. That's not how it works in Illinois. Judges are very particular of what needs to be in a will or or a power of attorney.
Yeah.
And yeah, it's just people just aren't. A lot of people go to the legal Zoom a little too much, and legal Zoom isn't state specific. So,
Yeah, yeah.
you
Well, just like everything else, you Google it and you can get your answer. So
right.
that's not always the case. And I'm glad you did speak a little bit on the different instruments that people think is protecting them, because just in my experience, people think if they have a power of attorney, that's all they need if a person passes away. And your response to that is,
A power of attorney is when someone is living. So a power of attorney expires upon the death of that person. You can't. A power of attorney does not extend beyond the death of that person. I the situation I was saying before, where attorney kind of led a client astray, was that type of situation. They put on the power of attorney that it's forever and always. No, that doesn't work in Illinois. Power of attorneys are statutory. There's certain language. You can't go beyond the
yeah.
person's death. The judge is not going to accept that or acknowledge it or anything.
Yeah. And that even goes for another instrument that people use is, okay, I did a quick claim. So if something were to happen to a loved one, then it was quick claim to me, and so I have all the power to do what I need to do with that property. Is that true?
I mean, so it depends is the answer.
Okay.
Some you again. This goes back to making sure you have the right attorney, because some people do quick claims when they don't have the right status to do so. So, for instance, someone can do a quick claim on a property that currently there's a mortgage attached to that property.
Right.
So a person could try to quick claim it to their family, to maybe their son or their daughter. The mortgage company is going to reverse that, because you can't quick claim a piece of property that is still inhabited by a mortgage. You can do it if, let's say, you are married and
Yeah.
you want to make sure that both you and your spouse are on title. You can do it that way, but
Hmm.
that's again goes back to making sure you have the right attorney, because there are some instances where if a quick claim is properly executed and properly recorded, then that property then belongs to whoever you quit claimed it to. There also are situations you have to make sure that the tenancy is correct. So in Illinois, you have joint tenancy, you have tenants in common. If you don't specify that it's a joint tenancy,
Hmm.
Illinois is going to automatically assume that it's tenants in common, which means that once that one person passes, it doesn't automatically transfer to the next person. It transfers to that person who deceased, their heirs. So then that makes it difficult. So again, you got to make sure you're talking with people who know what they're talking about to
Right.
make sure you're
Right.
doing the right thing.
Right.
Because
Right.
again, in some cases, a quick claim deed will work perfectly fine, but in a lot of cases, it just makes things worse. So
Yeah, yeah. And again, that's why I am so grateful that you are on the show, so that you can talk about some of those things that people think that they have the answer to, but they really don't. And when they find out is when it's too late, and then things get sort of little murky, and people, fighting and it didn't have to. So,
Right.
but when we're going to take a little break because we like to mix it up a little bit. We're going to take a break. And when we come back, we're going to talk about the probate process, what that looks like. What do you recommend? As you alluded to earlier, it's good that if people can start preparing now to prepare, because let's say this: death is definitely imminent. Most of us are going to make that journey, and so you need to start thinking about the what ifs. And when you're young, right, you don't think about those things, but you should, right?
You should. Yeah,
Yes,
I'd say
should.
as soon as you start a family, me and my husband are already getting our estate plans in order, and we're in our 30s. But
Yeah,
you
yeah.
can't be married to a probate attorney and not have
Yeah, absolutely.
that wouldn't
Absolutely.
make any sense.
Absolutely. Well, when we come back, we're gonna discuss a little bit more about the probate. Now, if somebody has some questions for counsel, if it's being shared on what is that? You can do a watch party. If you're in a watch party and you have a question, it would be better that you actually go to the live show with your question so that I'll be able to let a counsel know that you've got a question. So we'll be right back. So hold tight. All right.
Dancing slowly in the moonlight beneath the stars that lit up your eyes. The sweet scent of your skin filled up my lungs with ecstasy. I can't believe we were so young, maybe 20 something. We were living in a fantasy. I knew right from the start you were the other half of my heart. Ooh, half of my heart. Oh, I could spend every single day staring into your beautiful blue. Every single day, every single hour. We're growing older together now, but I still feel young when I'm with you. We were so young, maybe 20 something. We were living in a fantasy. I knew right from the start you were the other half of my heart. Wanna be so low, the other half of my heart. Wanna be so low, yeah, yeah. Wanna be so low. You make me wanna be something more. Oh yeah, we were so young, maybe 20 something. We were living in a fantasy. I knew right from the start you were the other half of my heart. Ooh, the other half of my heart. Oh, you were the other half of my heart. Ooh, yeah, the other half wanna be something more. Wanna be something more. The other half wanna be something
Right. So we are back. I'm Dawn Haley with the Windy City Live Show, and my guest is Lisa Glenn from the law office of Lisa Glenn. So we just to recap, we were just talking about that people in their 30s should start thinking about probate. It shouldn't be when they're 60s or 70s when they should be having those conversations, right?
Yeah, no, I say if once you have once you have a child or a piece of property, you want to start having that conversation, and as soon as you can, at least get something in writing.
Yeah.
That is what you are protecting. You're protecting your family, you're protecting your assets, you're protecting what you have. So um that's
Yeah.
always been my recommendation.
Yeah, and I think do you have an opinion as to why people don't think about planning? Do you have an opinion about it at all?
I think most people just don't want to think about death. I think that's the main thing. They don't want to think about the reason that they're having these conversations, which I understand. I get it.
Yeah, yeah.
Um, and a lot of times I hear from a lot of people, well, if I'm gone, I'm not going to be here to see the madness anyway. So why do I care? I've heard
Oh,
that
yeah.
too. So,
Yeah, yeah. But I mean, people buy life insurance. Isn't that kind of the same? But now you're just really directing what happens to your assets after, God forbid if something were to happen to you, or if
right.
you live long enough and, that time is, you're just getting approaching that time. So, but yeah, nobody really wants to think about death. I mean, but living in the environment which none of us could ever anticipated what's going on right now. And as you said, a lot of a good portion of your clients are coming from the loss of life due to COVID, correct?
Yeah. No. Yeah. Since when was the shutdown?
March of
March. Right.
last
Since
year,
March
yeah.
of last year, I'd say at least once a month, I get a new client whose loved one passed from COVID. So
Yeah, yeah, yeah. Well, and it's again, unless it's gonna get better, which is not gonna do that for a very long time. I think that's why it's a good thing to have you on my show today. And so let's talk about. I mean, the best approach, which you mentioned, would be to plan, but going on the statistics that most people learn about probate when someone passes away. So let's talk about what that give a general idea what that process looks like.
so I mean, it all depends. So in Illinois, the only reason you'd have to go through a court system is if the person who passed left a piece of property that wasn't jointly owned by someone who survived the deceased person, or if that deceased person has assets worth over $100,000. So most of my clients that go through the court system, the reason they're doing it is because their loved one left a piece of property, and now you have people fighting over who's gonna what's going to happen with the property. So they have to open up a probate to get someone named as an administrator, so that whatever ends up going on happening with the property, that administrator can then sign the proper paperwork to get the property transferred or sold if that's what they want to do.
Mhm.
Um, if there's no piece of real property and there's no assets over 100,000 in liquid assets, then there'd be a small estate affidavit that would be completed, and it would have to be notarized, and there'd be a list of the assets, list of the heirs, and you would use that along with the death certificate to show proof that this person passed away. These are the people who are supposed to get whatever's left in the estate, and whoever's signing as the notarized agent, they're now the authority over making sure that the estate is transferred over. But the worst case scenario is ever having to go to court. I always tell clients, you want to avoid court at all costs, but most people don't know that if they have property, a will is not going to keep them out of probate. You would need to either get a transfer on death instrument recorded, where the transfer on death instrument essentially says, when I pass away, this is who I want to take the property, or get a trust set up, and you can get the property moved into a trust. So then the trust would state who you want to have the property. Um, because once you go through probate, you have filing fees, you have attorney's fees. It takes on average 14 months to get a probate estate opened and closed. You have to wait on creditors. Creditors can file claims and then essentially force you to either sell the property or take a loan out on it to
Yeah.
pay the
Yeah.
deceased person's debts. And it's always better to avoid all of
Pro
that.
Oh, it's better to avoid, but again, in the real world, most people don't. They usually accidentally land into probate. And one of the things that I know you and I talked about some time ago, when you came on my first show, is that when you've got siblings that do not like each other, that
Mhm.
just adds another fray, another level that, wow, it's very difficult when when the judge has elected one person, and that one person everybody just doesn't like. And then, and then sometimes, which we talked about, sometimes siblings may not even know, because they don't have to be included. Or so you and I talked about that. If a sibling wasn't added into the probate process, what typically
Well,
happens
a
next?
sibling has to be notified. So a sibling would have to be notified. It's sometimes they don't get the notice and they find out later on what's going on, and then that's the issue. But legally, all heirs to a deceased person we're required to send notice if a decedent estate is going to be open. We're required to send 30-day notice specifically. So we send the notice. A lot of times the siblings will get it. They'll show up to court and they say, well, I don't want my sister over these things. And the judge will say, well, did you file a petition? And they'll say, well, what is that? And then the
Yeah.
judge will say, well, you need to get an attorney. You have to file, because that's the other thing with probate, especially if the deceased person didn't leave a will. You have to have an attorney for probate, because you have to get bonded to the estate, which is essentially insurance on the estate, to make sure that whoever is named administrator doesn't run away with the money.
Hmm.
And you have to have an attorney to get bonded. So
Yeah.
that's another thing that a judge will say, well, you can file a cross petition, but you need an attorney. And can you afford an attorney? No. I'll give you time to find one. They come back, there's still no attorney, and they're kind of out of the equation. However, legally, if someone passes without a will, their children, if they have children, those children will get whatever percentage they're supposed to get. Is just hopefully the person who's named administrator doesn't do anything
Yeah.
unethical. But
Yeah.
if so, that's why they have to get bonded with the estate, though. The insurance can cover it, but then that's more of a headache. That's now more that they
Yeah.
have to deal with. So
Now let's talk about if it says real estate is involved, okay, and that the person still had a mortgage on the property. And I know that with some, well, not clients that I've actually assisted with, but those that I do, I do help. But what I see is when people don't assist themselves with a probate attorney, and they're in a property that their parents or someone that they love is they're in that property, and they feel like there's nothing that they can do because their name isn't on the mortgage. The lien holder will not have a conversation with them because their name isn't on the mortgage, so they feel as if all they can do is just let that ship sink. So your advice is, if somebody finds themselves in a situation where they've lost a loved one, and that loved one has a mortgage on the property, and because their name isn't on it, the lender will not, the lien holder will not talk to them. What do you recommend that they do?
So it's all it depends. The answer is
I
always
know.
going to be it depends,
Oh yeah, well,
but it depends. So worst case scenario, they're staying in the house and they can't afford the mortgage anymore, and they want to work with the mortgage company in order to do a loss mitigation arrangement of some sort. They would have to open up a probate estate. There's honestly no way around that. A mortgage company is not going to talk to you if the person who owns that property and whose name is on the mortgage has deceased. They're just not going to talk to you without letters of office, and that's what you get from going through the probate estate. So if there's a chance that you feel that you have the financial means to get into a loss mitigation or some sort of repayment plan to get caught up or get a lower payment, I would highly suggest getting an attorney, taking that loss. If this is a house that you want to keep and want to stay in, there's no way around around that. You have to get letters of office. The mortgage company is not going to talk to you unless you can pay them off, pay off the entire balance in full, pay it off, and then they'll record the title or release in Cook County, and then you can record the proper paperwork showing that the person's passed away, and these are the heirs and all of that. But the hope is that the heirs are actually that they get along, because if there's more than one heir and only one heir is staying in the house, you still have to get everybody on board to sign off that. So let's say you do pay the mortgage company off in full and they record the release. Everybody, all the heirs have to then agree that, okay, well, you paid it, so you can just have the property. If they don't have to agree to that though, because in Illinois, they're all entitled to a piece of that property. So again, you just got to hope that you all get along. So I mean, I don't even know if that's worst case scenario, but that's one scenario. If you can't afford, if the person passed away, they were the ones making the mortgage payments, and you just can't afford to keep up with the payments, I would highly suggest, if again you have heirs that get along, you can actually avoid the probate process if all the heirs can agree to sell and all heirs agree to sign off on sale documents. You can go through the title company, get a bond through the title company, and you can sell the property, and hopefully you can sell it for a profit. And
no, go ahead. I mean, you just brought. I see. I always learn from my guests, but go ahead and finish your thought.
Well, yeah. So in situations where there's no way you can afford to make payments on the mortgage, you're not even sure, like you don't even want to deal with the mortgage company in that sense. You can get the property sold as long as all heirs are in agreement. The only issue you sometimes may run into is getting a payoff statement from the mortgage company. But I've had one scenario. I've had one scenario that we kind of had some issues with the mortgage company getting the payoff, but we eventually got it because they want to get paid.
Right.
But so that's one way of avoiding probate. If, like I said, in a situation where you just know you can't afford this property, you can't afford the mortgage, hopefully the property is worth more than what's owed on it, and it might be worth selling. And then whoever are the heirs are all in agreement that we're going to sell this property, and the proceeds will get split. So that's one other method.
So basically, then talking about the title company. So they would so the siblings or sibling or one person, to avoid having to go through probate, they would need to, and how would they, I mean, I think I know the answer, but I'm just kind of probing it out of you. How would they then know to go to which title company, or does it matter what
they would have to go to an attorney, because that attorney would then use their title company. The only thing with going through a title company though is they're going to charge you fees that are probably a lot higher than what the attorney would charge you. And I say that because when you're going through a title company, you have to get a bond based off of the value of the home, and that bond is usually 3 to 5% of the value of the home. So if your home is worth 100, if the home is worth 100,000, the bond they'd be paying. I'm really bad at math.
Okay. Is that 5,000?
5,000?
Yeah, 5,000.
Yeah. They'd have to pay that out of the closing costs.
And that's in addition to all the other costs.
In addition to all the other costs. So,
so it's better to go through, and it's better to go through.
It's usually better to go through. It's cheaper to go through an attorney's go through the probate process. Yeah. And the other issue could also be if you're not in probate, and you can't talk to the mortgage company. Let's say you are trying to sell the property and it's taking a lot longer than you thought, and now the property is going through foreclosure, and now you still can't talk to the mortgage company to try to stop. Right. So it's a riskier move not going through probate, but it is. I always provide clients with that option if the only piece of property, only asset is a piece of property that they know they don't want to keep,
Yeah.
and if they have siblings that are all on board,
Yeah.
and
So
they
the
understand that you're going to be paying more
yeah.
going that
So
route.
so I would say then the moral to that is don't think there may not be answers out there for you. The worst thing you can do, which a lot of people do, is wait on answers. And when someone passes away and there's property involved, you've got to really be proactive. And you got to be cautious too, because there are
Yeah.
people out there that'll take advantage of you because they know you're in a vulnerable situation. So it's like you said, you want to do your research and make sure you're working with people who are experienced in that area so that they can help you get through a very difficult time, because it is tough, and you can be led down the wrong beaten path. So but we're going to take another break, and when we come back we're going to talk a little bit more about some other things that need to be in that you need to consider when you're looking at probate. So we'll be back and continue that conversation. All right.
Let's go to work, 'cause I'm tripping. Gotta work on myself, 'cause I'm falling apart. Please wake me up, 'cause I'm slipping. Can't fight this feeling off no more. But I'm not going to give up and fall. Rise above the door, meet all my challenges and search for my strength. I defeat them all, I'm never ever gonna hide no more. I come to love myself again, yeah. For all the things I didn't know, the pain, the hurt, I let it go. Start to believe in myself and life will be sweet again, so sweet again. Above it all, beat all my challenges and search for my strength. I defeat them all, I never ever gonna hide no more. I come to love myself again. For all the things I didn't know, the pain, the hurt, I let it go, let it go. And I start to believe in myself, and life will be sweet again. Oh na na, oh na 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 na. When all I see is darkness and gloom, yeah, I'll be running from my doom. Oh na 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 na. But now it's time to live my life, but now I know what I need to do. Oh na 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 na. When all I see is darkness and gloom, yeah, I'll be running from my doom. Oh na 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 na. But now it's time to live my life, but now I know what I need to do.
All right. So we are back, and some good stuff. Counselor, good stuff, good stuff. So again, I just want to say, based on what I'm learning, is that it's best to not just wait on a solution. You really have to be proactive if you find yourself in a situation where a loved one has passed, and there's still a mortgage, and you just don't know what you need to do, but there is some answers that you can seek out and figure out how to get through that. So thank you for that bit of information. Appreciate that. Now let's switch gears for planning. Let's talk about what people could do to begin to plan, be it a will, be it, I think you shared with me there, you need to just not have a will. There are other instruments that need to be attached with that, so that it's well protected or well cushioned to do the things that you want, your desire, when someone passes away or when you pass away. I'm sorry.
Yeah, I mean, essentially, if your goal is to keep your family out of court, a will is not going to be enough. A will helps with the fact that will at least tells the judge how the estate is to be administered. That's helpful, but you still have to go to court for that to happen if there's a piece of property. Did you go away?
No, I'm still there. I'm letting you
Oh,
talk. I'm putting the focus on you.
oh,
So
okay. Well,
no,
that was
I'm
strange. Okay,
no, no,
you
no.
probably should have given me a heads up of that.
I'm
Okay, but
sorry.
um,
My
I
bad.
don't even
Go
remember what I
ahead.
was saying. Okay.
No, you were just saying that a will is not an instrument. It will not
If
be
you're,
the
yeah,
only instrument.
if you're trying to keep your family out of court, a will not keep them out of court if there is a piece of property or assets over $100,000 that are not, if you have a bank account with 200 grand in it and you don't have a named beneficiary, that your family is going to still have to go to court to get that administered. And a way to avoid that is to either get a named beneficiary on the bank account or, set up a trust. But yeah, so a will helps the judges. It helps the attorneys and the judges because it helps us know, okay, well, this is how everything is going to get dispersed. But you still have to go to court to administer it. To avoid court, if there's a piece of property, you want to get either a transfer on death instrument recorded, which not all states recognize transfer on death instruments. Illinois is one of them, thank God. So if you have a piece of property in Illinois, you would record a statement that's essentially stating, this property belongs to me. You can have a mortgage on the property, that's fine. But this property belongs to me. When I pass away, this is who I want to have the property. So
Mhm,
that will help. Again, if there's a mortgage on the property, now the mortgage company understands that, oh, okay, this person was named as the transferee of the property, so I can talk to them. However, usually recommend doing a transfer on death instrument if the property is paid off, but it really doesn't matter. It does the same thing. Or you can set up a trust, and in that trust, if it's a type of situation where you want the property to stay in your family for years to come, you can set up a trust, and in the trust, the language is going to say, I want this person to have a life estate in the property. Once that person
mhm,
passes away, their family gets a life estate, and so a trust can help in that way, and both of those instruments will help keep you out of probate court.
mhm,
For the
mhm.
piece of property. Like I said, for the liquid assets, you want to at least have a beneficiary name. You want to go to your bank and make sure there's somebody on file as a beneficiary.
Right.
But if that's not the case, then your family still has to go to court. So
Right. Well, as just from somebody who's listening and who will be listening, hopefully, they might be thinking in their head, that sounds like that's a lot of money to do something like that. And what would be your answer to that? I mean, I don't want to put you on blast about what your fees are, but
I mean,
uh,
my fee. If you go on my website, I'm very transparent with my fees. So I have ranges for fees. It all depends on the situation, obviously. But if you want to know my fees personally, you can go to my website. But I always say though, when it comes to estate planning, it's better to spend the money now than have a bunch of the money being taken out later. And
mhm.
I know when it comes to people when they're passed away, they probably don't care. But if you care about your family, you want to make sure that they don't have to pay too much more out of pocket because it's a lot more expensive to go through the court the court procedure, as opposed to, getting a will or a trust set up.
Yeah, and
Or
I just posted your website in the chat. So I would encourage, I know I'm partial, but I would encourage people who may have questions or just would like to get some information about this process. Please call Lisa. She's very easy to talk to. She's not kind of like, okay, she's an attorney, she might talk over my head. No, she will make you feel very comfortable and down to earth about your concerns about this entire process. So I just had to get that dig in there. So go ahead. I'm sorry.
appreciate that.
Mm-hmm.
Oh, I don't remember what I was saying.
You just, you know what it is, you just go off on those serious things about what people need to be doing. You were just basically just reminding people that your fees, people can visit
Is
your website and
Yeah.
and talk to you about the ideal of trying to get themselves prepared for the inevitable. I mean, and that's pretty much
And I will say, especially when it comes to power of attorneys, because power of attorneys are for when the person is still alive. So if the person doesn't have their power of attorney set up, then you're making your family have to go through the guardianship probate courts for guardianship. And guardianship, you get paid from the estate. So if that person is getting a pension, the pension is now used to pay for the attorney's fees and the court costs for guardianship. So in that case, they actually are losing their money. Their money is being lost while they're still living. So,
wait
at
a
least
minute.
get the power of
Let me
attorney in order.
explain that again. I want to make sure I understand it. You said if the
So
person was receiving pension and they passed
no,
away.
for guardianship matters. So
Oh,
if
I
the
got you.
person is still living,
Gotcha.
the fees for guardianship 9 times out of 10 are being paid from that person's estate who's still living. So their money is getting drained while they're alive because they didn't set up a power of attorney and have someone. And you want to name someone under your power of attorney that you trust and that is trustworthy to other people, because that's the other issue, especially like I said, during COVID, a lot of families issues, and one of the issues are power of attorneys and the family members saying the power of attorneys and doing their job, so then they file guardianship. It's just
Right.
it's been
Yeah.
it's been
Yeah.
crazy. And all along, the person who is still living, who now has a disability, their pension is getting ran through and their savings are being drained because now you have family fighting in probate.
Yeah.
So,
Yeah,
you know,
it's sad. So, you really, if you're in your right mind, now is the time to set up these important instruments. So, yes, visit Lisa's website and have those conversations with her, because she and I do, I want to share, she and I do work together on probate, estate filings, in terms of I act as the realtor when there is a property that needs to be sold, and so Lisa and I work together to try to get that process completed. And I would say most of ours have been pleasant. We've haven't had one that we both had to scratch our head and say, "Huh." But
not yet.
not yet. But there's always a first time for everything. But we're gonna take our final break before we end our show. And when we come back, Lisa, we're gonna find out how people, if there's anything else that you'd like to share regarding the process, the actually real estate. If a person is thinking about selling, what can they do once they've been given the what is that? You'll have to tell me what that legal term is once the courts give them their
Their letters of office.
letter. There you go. There you
Mhm.
go. So when we come back, we're going to talk a little bit about that, and then we're going to close it out. So I'll be right back. All right. So
These
we
are some
are
interesting musical choices. That's
yeah, well, I just like to I
so
just
was it
like
the
to
first song or the second song sound really good? It sound like Eric Benet, but I don't think it was
uh
Eric Benet.
no, it's not Eric Benet. These are not your what do you call it? Your celebrities or songwriters that are hot on the chart. This is I kind of go through deep in the canal to try to find these songs. But anyway, I wanted to end by at least saying we were talking about real estate. Now, if a person does have, if they have to go through probate, do they have to wait until they receive the green light to sell, or can they put the property on the market as they're going through this process? Tell us a little about that. How
Yeah,
that
so they would need to wait until they at least get the letters of office. So with probate, you're looking at about 30 to 45 days from the date that the petition is filed to the date you actually get your certified letters of office. Once you get that, you're able to list. You can list the property immediately. If the person passed away less than 2 years from the time you've opened the estate, you do have to wait 6 months before you can. So let's say before you can actually disperse the proceeds. So let's say you're lucky and you list the property and the property is sold within a month of you getting your letters of office, and then you get the proceeds. You still have to wait at least that 6 months
Uh-oh. She okay, you
before
wait a minute.
you can actually
Repeat
disperse the proceeds from the sale of the estate. But you do need the letters of office first. You need to get that first. So
you're kind of
what's that?
freezing up. You're kind of you just froze up.
Oh no, I'm
Repeat that.
freezing.
Yeah, repeat that last let's say the last minute of what you were talking about. You said that if they did not get the letter of authorization. Did you hear me? Uh-oh.
Yeah. Can you hear
Okay.
me?
I can
Oh
hear you now.
no.
Well,
Hey,
that's
can you
fine.
hear me?
I
It's
can hear
always
you.
at the
Just go
last
ahead and
10
finish.
minutes. But yeah,
Yeah, the last
they need the letters of office to move forward.
okay.
They can't move forward with the sale of the property until they have those letters of office.
Okay.
And I was just saying it's important to know that you still have to wait that 6 month if the person passed away less than 2 years ago
Mhm.
from the time you filed the petition, you still have to wait 6 months before you can disperse the proceeds. So if you're lucky enough to sell the property a month after it's listed, once you get those proceeds, you need to put those in an estate account. A lot of times, I'll just recommend clients have that proceeds check go to me, so I'll put it in my trust account, and then once those 6 months are up, then you pay out to the heirs. And if creditors file claims between that time, then that whatever is in the proceeds will automatically get paid to the creditors first, and then whatever's left would get dispersed. So it's
So
important to
you're
know the timing for that too.
So you're telling me, which I know the answer, but I'm just probably somebody else who might be thinking this. But so you're telling me that once a loved one passes away, unfortunately, creditors will still have to be paid, so the debt doesn't die with the death of the
The
family. Yeah.
the debt doesn't die unless you open there's a 2 year period that if it's 2 years after the person passes away, you no longer have to provide a notice to creditors. Now if there's a creditor that has been constantly sending notifications and saying this stuff needs to get paid and it's been 2 years, then you have a fiduciary duty to then pay those creditors, but you don't have a fiduciary duty to give creditors notice after 2 years.
Oh, okay.
So
So there is a little well, is what is that? A little I can't think of the word right now, but there is a option to get around that. That
there's
that'd
a
be
way to get around. A
yeah.
lot of times for my clients, if it's like if it's less than 6 months from the 2 year period, I'll just tell them it might be best for you to just wait 6 months. I've had clients that it's been a rush situation. And I've always felt bad about that because then these creditors are now filing claims, and it's like, well, we could have
Yeah.
waited. We could have
Yeah.
waited a few months, but I got why we had to do it then. But
Yeah.
yeah, if it's within 6 months of the person passing, I just let the people know, hey, let's just wait 6 months so
Yeah.
that we don't have to let creditors know. Usually the only creditors that need to be paid at that point are mortgage companies and maybe credit card companies that have still sending statements, but we don't have to send notice. So
Yeah, yeah.
can
Well, oh,
avoid.
so the word I was looking to say was get around. So there's a way to get around it, but
There's a way to
it's
get
got
around. You just have to wait 2 years.
yeah,
You have to
yeah,
wait 2 years, which a lot of people can't wait 2 years,
yeah.
depending
Well,
on the situation. So
yeah, which is understandable. It just depends on where a person, where people are financially that can allow them the time to wait. But I just want to go back to the best armor you can have is to educate yourself, to know and really seek out professionals who are that's their area of expertise, their area of law. And so that's why I brought Lisa on. Yes, she's my daughter. I get it. But I know she knows what she's doing, and she does look out for her clients and for the best interest of what's best for them. Because I will share this story because this is not it's not it's not your client, my client, but just to give you a reality check of there are people out here that will take advantage of the elderly. And
yes,
unfortunately, we have a family member where an attorney took ten thousands and thousands of dollars from a family member because she just didn't know. And then when she wanted to know, then she called you.
and I
But
know
it
you're
but
talking.
yes,
I was
but
wondering who you talking about. Oh,
yeah,
okay, I
yeah,
know
yeah,
you're
yeah. Well,
talking.
I just,
Yeah,
I don't wanna put
yeah,
our family member on blast, but the kind of money that, our family member paid when she could have simply picked up the phone and called you would have saved her
yeah.
thousands and thousands.
I don't know. I don't remember if I was on my own. If I was
You
doing.
were.
Was
You
I? Oh
Yeah,
shoot.
you
Oh
were.
darn.
Yeah,
Yeah.
you were, you were.
Yeah. Yeah.
Yeah,
No.
you were. And I understand people don't want folks to know their business, but when you've got a family member that looks out for best interest for anybody, they're going to look out for the best interest for you. So
Yeah.
that said, Lisa, let's post up your information again. So if anyone is interested and just want to talk, please, I believe I posted Lisa's information on the website, or at least in the comment. So please look her up. Lisa, is there anything else you'd like to share with our guest?
No, just I just hope that people understand that the area of law that I practice in is not fun to talk about, but it's
Yeah,
necessary. So,
yeah,
and you want to make sure if you are ready to have those conversations that you're having a conversation with attorneys who are not trying to just take all your money. And I
yeah,
say it all the time. It's not it's not always for my benefit, but I always tell clients like I'm not in this to get rich. If I get rich, great, but I'm not in
yeah,
it to get rich. So
yeah,
I'm not trying to nickel and dime you. I'm just,
yeah,
you
yeah,
you want professional help. If you want it done right, sometimes you got to pay for that. So,
yeah, yeah.
but I just try to be as fair and as honest as I can with everything that I take on. So,
Yeah, and she's also a great real estate attorney too. Although I mean, she does her practice is estate and estate and
I mean, I
probate.
do it, but I do it all because, as like you said before, you want to make sure you have attorneys who that's their focus. Like my focus is probate, adult guardianship, real estate closings, and estate plannings. Like that's where I focus. That is where I do all of my learnings. That's all of the organizations I'm in. That is my focus. So real estate is included. I do just as much real estate as I do decedent estates and adult guardianship and estate plans. So
Yes, you do. Yes, you do. And I'm so thankful for that because I'm going to share this and everyone, I'm going to say goodnight. I've been in this business for 30 years. And when I started, I was holding Lisa's hand and I don't think you were an arm baby. I don't think you were an arm baby. Or you could have been an arm baby. I was still carrying you and showing houses with them. And here I am now, doing business with my daughter. And that's a beautiful thing. So nonetheless, I digressed a bit, but that's always a good thing. But at any rate, everyone,
such
I
is life.
hope I hope you enjoyed today's show, and please share and share, because it may not be something that you think you need right now, but somebody else could be in that seeking and searching process. So thank you. Be safe out there. And I will be back next week on Tuesday. And Lisa, do you want to leave anything else with the folk?
Oh no, that's all. Just visit my website and give me a call if you need my services.
Yes, please visit her website, everybody. Listen, take care, be safe.
Stand by you when you're falling, when the river is calling. Said I love you forever, we can make it together. What goes up must come down. There's lots of friendly faces all around, and nothing's ever lifting me higher than a touch of your sweet desire. Well, we're all built and right. We just have to hold on through the night. As long as we are watching the fire, we'll be safe from the devil's choir. Stand by you when you're falling, when the river is calling. Said I love you forever, we can make it together. Yeah, yeah. When things go wrong, it's easy to sing a sad song. Seems like nothing comes for free. Yeah. And it won't take love, your fragile soul will soon be strong. I'll carry you so tenderly. What I wanna say is that I stand by you when you're falling, when the river is calling. I said I love you forever, we can make it together. Breaks my heart seeing you struggle with the things you do, carrying the one on your shoulder. When did we become so much older? Now I wish I could say that all my trouble's gonna blow away, but I won't quit until it gets better, even if it takes me forever. Stand by you when you're falling, when the river is calling. Said I love you forever, we can make it together.